So I filed a motion to dismiss, suppress evidence and dismiss Ransom. And, we'd like to play the video, so I'd like to move for admission of the video will be defense exhibit A, dashcam. And the crux of our.
I'm sorry, just a moment, counsel. Mr. Kuzniak, any objection?
I don't know exactly what you're going to be presenting. I mean, for purposes of argument, I think you can utilize that to raise the argument at the motion, but to admit it into evidence and to later be used at trial, I don't know if that's appropriate.
Okay.
I can present the evidence. I mean, she asked me if I had any evidence to admit it. I have videos. I don't know if the court wants to move for admission or if you just want me to present the videos. Mr. Kuzniak, sorry, Your Honor, I should be standing. There were videos provided to me by the prosecution that had an opportunity videos that came straight from the police officers, so I'm not sure why it would be the issue to admit it. And kind of time.
I think what I was hearing is the issue is whether or not they would be admitted as an exhibit as far as evidence goes, or is it more to support your motion?
It's to support my motion. It doesn't matter either way.
Okay. All right. Well, I'll hold that in abeyance. I'll let you continue with what you were going to.
Very good. And the reason why I bring the video, it really speaks for itself for that. What you'll see in the video is the police officer fails to articulate or have any justifiable reason to stop the vehicle. First, he claims that she was coming out of a parking lot, almost hit a car. That never happened. It's clear in the video. And then he says that she failed to maintain her lane. That also never happened. It's also in the video. You'll find that there was no breaking of the law. She was absolutely compliant. And then most importantly, even if we can see that there's a reason, we can find it in the light most favorable to the police officer's testimony or the police officer's what he wrote in the police report. Even then, he can't expand a traffic stop without articulable reasonable suspicion at all. And he doesn't say that there's any odors of intoxicants coming from her mouth in the vehicle. There's no evidence of slurred speech. There's just nothing. He goes straight into OWI interrogation, and that's kind of, you see, she comes out of the parking lot, and he just immediately starts following her. Major red flags all the way around, and then you can see after stopping her, he immediately talks about whether she drank and so on. Even in the field sobriety test, Your Honor, there were no issues. She wasn't wobbling. He tries to trip her up several times. And even maybe once where she made a mistake, she caught herself immediately and then went back and corrected herself. There are absolutely no signs of intoxication. So even if the court finds there was reason to stop her, he feels reasonable articulation of suspicion. There's no probable cause. All of these things are dismissible reasons, from the initial stop to the lack of reasonable suspicion to the lack of probable cause. And when we present the video, you're going to see just that.
Okay. Mr. Kuzniak?
Your Honor, Mr. Arago was presented an argument to the court. However, I don't think it's a complete argument. Mr. Arago indicates that there was no reason to pull the defendant over. However, in the police report and in the testimony that would be elicited from police at trial, it indicated that the police officers observed the defendant's driving and that the driver had almost struck a parked car with the door open. That wasn't caught on video because the video camera wasn't on. The police officer was driving in one direction, she was driving in the other direction. The police officer then had to turn his car around and follow the defendant. And that's where he noticed the defendant driving into the 7-Eleven in Chestnut area, and then followed the defendant, where he indicated again that she had difficulty in the lane, also observed a back light on the license plate not being operable. And for those purposes of the initial vision of the defendant driving, almost striking a car, to her subsequent driving to her stop, gave what we believe is probable cause to effectuate a stop, number one. Once stopped, police officer made appropriate investigation of the defendant, and by the defendant's own admission, it indicated that she had been drinking, failed a simple little test of, question of whether or not to do a 9 or 11, what is the middle number, and she picked 9, and then turned and offered the various field sobriety tests. According to the police officer and police officer's testimony that would be elicited again at trial, the defendant failed those field sobriety tests. She also then refused to take the preliminary breath test, and then she was taken to the station, where she then did register in excess of the legal limit with regard to the breathalyzer, intoxilizer. Your Honor, we believe that the stop was valid. We believe that the actions of the police officer were valid. We believe it was an appropriate stop and appropriate issuance of a citation.
Okay,
Your Honor, may I briefly that?
well, I think I can watch the videos. Any objection to me watching the videos?
Your Honor, I have no objection to watching the videos. It's basically, it wasn't an evidentiary hearing, so we weren't going to elicit this or make this a part of the record, but allow the video to be viewed for the court's determination.
Thank you very much.
Okay.
So I have to grant access to the.
To screen share? That should,
Yes.
yep, it's on the bottom. It's open. It's
I've got maximum protection on my computer. It's asking me to put in my password.
oh, for you. Okay.
Yeah.
Okay.
Then log back into Zoom. Here, prosecutor indicates that he had to turn around somehow. The police officer observed something and then had to turn around. This shows the police officer parked, not turned around, and clearly wasn't in pursuit at any moment in time.
Okay, let me just ask one question. Mr. Kuzniak, is this, because in your argument, you stated that the officer, turned around and then waited for, Ms. Palazzolo to exit the 7-Eleven parking lot. Is this before seeing Ms. Palazzolo with the car, or is this after they turned around and noticed she was in the parking lot?
Yeah, Your Honor, this was a video that started, but it was after the initial contact that the police officer had with the defendant.
Okay.
Initial contact occurred on Oak Street. The police officer was going westbound on Oak Street. Solo was going eastbound on 4th Street. That's when the police officer observed the door being open and Ms. Palazzolo, the defendant, almost striking that car. Then Ms. Palazzolo continued eastbound onto 1st Street, made the right turn on 1st Street, and then turned in, came down, and eventually ended up in the 7-Eleven. The police officer turned around, had a turnaround, followed the defendant back, parked, and then observed the defendant re-enter the car and then drive away. So the biggest argument that the defense counsel raises is that, some of the issue about probable cause and why to stop. It's not, and it's my understanding in talking to the police officer that the video doesn't automatically kick in because in effect the police officer is driving eastbound versus the car coming westbound. When he noticed it, that's when he was able to turn around and follow the film.
So wouldn't it make more sense if we had the testimony of the officer?
Well, you know what? We've adjourned this several times, Your Honor. We knew exactly what we're going to be doing here. He didn't prepare his witness properly. We're not going to adjourn it. I'm asking, Your Honor, not adjourn this again. And relying on Mr. Kuzmiak's testimony, it basically would be akin to hearsay testimony of a police officer.
Well, okay, just a moment. We set this for a motion hearing, not an evidentiary hearing. So a motion hearing is a motion hearing on the legal arguments, which is not necessarily requiring any witnesses to testify. If it was set for an evidentiary hearing, then absolutely there should have been witnesses here to testify.
Sure, it may not require it, Your Honor, but he's certainly at leisure to bring witnesses to a motion hearing, as much as I'm allowed to present evidence of the same.
Well, I mean, I would presume that perhaps anybody can bring a witness to anything, but
I don't have to.
not necessarily for a motion hearing specifically. Typically, if it's set for an evidentiary hearing in this court, that's when witnesses are subpoenaed or required.
I understand that.
Okay.
But if he was going to admit or offer testimony that is not somehow in the video or corroborated by a video, I think it'd be prudent enough to bring that witness in, or at least call me up and say, this is what we need to do instead. I don't need a police officer here, so I'm not gonna call it. And
This is a motion hearing on a legal argument to dismiss. There's not been a request by either party, either side, as to whether or not it should be set for an evidentiary hearing, and this court didn't order it set for an evidentiary hearing. I set it for a motion hearing.
sure, and I don't need that. I don't need an evidentiary.
So, okay, so I may need an evidentiary hearing, but we'll see.
But to allow Mr. Kuzmiak to basically testify for a police officer, I think is wrongful.
Counsel, just so you're aware, I'm listening to both of your arguments as far as each of your positions as to the stop, where the stop occurred, what precipitated the stop. Okay, and so I've already heard, absent any conversation or specific verbatim discussion between Mr. Kuzmiak and the officer, right? I'm looking to see with right here what this is. Okay. So, and I'm also very much aware, which I'll take judicial notice, that it's my understanding, so I guess I really can't take judicial notice until this is confirmed, that the do the cameras flip on when the lights flip on, or is the camera on all the time?
The camera's not on all the time. It's only when the police, eventually effectuate a stop or begin the process of that. It's my understanding.
Okay, so if they're driving down the road, it's not necessarily on capturing everybody's driving.
Your Honor, first of all, that's not the case, and I'll tell you why. Because he's clearly not effectuating a stop at the time that this video starts. And if he saw something that would tend to support any evidence of probable cause for a stop, he should have activated it then. So allow some sort of testimony, or even take that into account when video doesn't even corroborate that. And since it's within his control to activate the video in order to preserve evidence, if it actually exists, he should have done that at that point. So I'm asking that Your Honor just consider the video as evidence. It's uncontested, unlike officer testimony, who's not even here, really just taking.
Well, I don't know about uncontested. I think sometimes video can be taken out of context. I don't know about uncontested.
I'm sorry. I was saying that this video actually exists, and this is the police officer, and that's the day that it happened, and this is the incident involved. That's what I'm saying. This is an uncontested video as to the fact that this is demonstrating what happened that day, or has captured what happened that day. May I please continue?
Your Honor, if I could only reply briefly, is the fact that defense counsel is fully aware of the position of the prosecutor. It's laid out in my response to his motion, with regard to his comment. He believes that the only thing that can justify stop is what the video provides. I said that from day one, that this is within the officer's prerogative to investigate a situation which he first identified with the driving on Oak Street, which was far apart from this particular location.
Sure.
Again, as the court indicated, if the defense counsel wanted an evidentiary hearing, but have asked for it, we would have provided our witnesses to that effect. We're not required to provide our witnesses, at a motion hearing that is allegedly on basically a legal claim. And we find, and our response is there to support the position of the prosecution that this was a valid stop.
Sure. And that means anybody can just fabricate a story that's not captured on video in order to justify why they didn't do it first.
So, counsel, are you suggesting to the court that if something is not on video, it did not occur?
I'm suggesting that one should practice caution when relying on that sort of information. If there are other inaccuracies that are later demonstrated through the video.
So if I went over there and did a whole set of jumping jacks that was not covered on video, and then later on somebody saw me sweating on video, is that right there conclusive as to what happened?
You could have been playing basketball instead of doing jumping jacks.
Well, right, correct. So my point is that just because it's not captured on video with exactly what happened doesn't mean that an individual's direct observation is minimized. That's my point. So it appears as though we need the officer to testify.
Well,
Because I don't see how I'm going to be able to make any sort of ruling on a legal argument without having some factual testimony from the officer at issue before I can make my ruling on whether or not there was probable cause for the stop.
well, Your Honor, and I would just ask that that's not necessary because the video shows a certain thing. And in addition to that, even if the stop is totally fine, everything after that is not. So we really don't need the police officer's testimony. The video speaks for itself. I believe that you'll find that there's enough basis to dismiss this, even if there wasn't a reason for a traffic stop.
Okay, so are you stipulating that there was a reason for the traffic stop?
I'm saying there's not only no reason for the traffic stop, but even if the court finds that there was no reason to expand it into an investigation for operating while intoxicated because there's no reasonable articulation, because after the stop has occurred, we can see that the video's already started. So it doesn't really matter what the police officer.
But this is not the stop because your client's still at 7-Eleven.
I understand, but we have to start with the stop first, Your Honor. We have to start where we start, and then we'll go into the body cam footage. And that'll. We don't need an evidentiary hearing. We've done a ton of time. We know what the police officer is going to say. It's exactly what's in the police.
No, we don't know what the police officer is going to say, counsel. I don't make any presumptions nor assumptions as to what any testimony is going to be. I don't have the video or the ability to view video that's not presented to the court. So both counsel has been able to view this video umpteen number of times, all the videos that there are. So you may be able to presume what is going to be testified to. I cannot. So we don't know what's going to be testified to, but proceed with the video. At this point, I'm going to determine whether or not I'm going to need the testimony of the officer before I can make a ruling on your legal argument.
Thank you.
So when you press play and you press pause, please make sure you are identifying the time on the video for the record.
Thanks.
Yes.
So here we observe at the start of the video, police officers park, not in pursuit and not moving. Simply, you can call it spying. Until immediately when she makes a turn, she's using her turn signal. This is at 10 seconds in. And she makes a full and complete stop at the light. She's got her turn signal on. No evidence of anything. His lights are not activated yet. He indicates that she failed to maintain her lane. As you can see, Your Honor, she's right in between both lanes. There's not a single issue. She's not weaving in and out. This is at 22 seconds in. Again, doesn't have any issues maintaining her lane. And then about 30 seconds in, so basically less than a minute from her leaving the parking lot, he pulls her over. Again, she activates her turn signal at 33 seconds in. Nice and smooth, not swerving around. No issues at all. Makes a nice smooth turn, 44 seconds in. And completes a stop. Doesn't? 53 seconds in, doesn't try to flee, elude, no issues. She immediately is coherent enough where a police officer activates his lights, she pulls over, full stop at the red light, using a turn signal both times. That's all I'm going to play from this one, so I can activate the body cam footage.
Well, no. If you want me to review to view this, I mean, I need to see this in its entirety. No.
Not the dash cam, because you're not going to be able to hear much. The body cam is the most important. Once he gets out of his vehicle, there's not much to see. But I'll play the next minute, and you can make that determination.
Correct. Thank you.
Absolutely.
Because I'm presuming at some point your client's going to be stepping out of the car, correct?
No, there's a conversation that takes place, and that's why I wanted to play the body cam footage.
I understand that, but at some point the dash cam is going to capture your client stepping out of the car.
Very briefly, because
Okay, and that's what I want to see.
Absolutely, Your Honor.
Do we know, is that music coming from the?
That's coming from the police officer.
Okay.
Where do you go?
I'll give you guys time to there, south on 75 at North Line. Taylor drove off the freeway into a ditch, and that see was notified. 10 minutes available.
Here, Your Honor, you can see that she neither wobbles or stuff.
Sorry, what time did you pause that, counsel?
Absolutely, 3:37.
Okay.
That was just indicating as she exits the vehicle, you don't see her, wobbling, falling over, failing to maintain any balance. She's.
I know, counsel, I can observe. Please. Okay, you can pause this because it appears now she's made me out of camera view.
Yep, and that's at 3:57. We stopped the video with dash cam footage. May I proceed to play the body cam footage?
Yes.
Thank you, Your Honor.
As to which officer, it appears as though there are three.
Yep, so this is the officer that approaches her driver's side.
Right, what's the name of which officer?
Officer Saltzman.
Okay.
Hello, what's going on?
I'm going to my house.
You going to your house?
Yes.
The reason I stopped you, so when you were on hold, you were coming down, that person had the car door open, you almost hit the car door.
I did?
Yes. And then you turned,
I didn't even notice.
you turned northbound on the first, and obviously, you went,
To 7-Eleven. I just left 7-Eleven.
you went pretty quick down Cedar.
Sorry.
On a Chestnut correction.
I'm so sorry.
And then your license plate lights
Did
are off.
my what?
Your license plate lights,
They're not on?
they're not working at all, so they're probably burnt out.
I didn't know that. He is getting my. Do you want it?
Yes.
You should ask for it, yes. That's it.
And when you turned out of, Chestnut, you pulled on the middle,
Yeah.
and you crossed over that lane line, so you're driving in the 2 lanes for a second.
So, Your Honor, we don't see that happen at any point in time. There's no crossing or right lane that happened in the video. I'm just making that record.
Okay, counsel, that's your observation.
Exactly.
I need to watch it a little bit more closely, rather than from the quick bit that I saw it. So that's your perspective and that's your argument,
It is.
clearly.
Thank you.
Okay.
Sorry.
Where you guys coming from, Tiana?
So we literally just left my friend's house on Eureka and Orange.
Okay.
Sorry.
Then where you headed to now?
Home on Emmons and Bill, basically. Emmons and First, I guess you could say, but I say Emmons Middle.
Okay. Do you have an idea, you sir?
So, Your Honor, just by way of making a record, she's able to decide exactly where she lives. There's no slurring of her speech. It's absolutely coherent. Okay,
Yeah, that's your opinion, counsel.
And I'm allowed to make a record, Your Honor.
I'm not saying that you can't.
Thank you.
You want it? Yes, please.
My name is Debbie.
Thank you. Tiana, how's your record?
My record is actually slow.
Have you ever had to take a trailer?
About 6 years ago.
Okay.
Why?
What was it for?
Speeding.
Speeding?
That sounds terrible, but speeding.
Tiana, how much are we getting for that?
Not a lot.
Not a lot.
Nope.
So how much is that?
Couple beers.
Couple beers.
To me, that's not a lot.
Okay. On a scale of 1 to 10, 10 being the most drunk you've ever been.
The most drink I ever had is 10. The most drink it, like, to me right now is about a 3.
About a 3?
Yep.
Okay. Can you give me a number between 9 and 11?
9.
Okay. Can you do me a favor and hop on the car?
This was in the prosecutor's opening arguments. He tried to bolster his position by saying she couldn't give a number between 9 and 11, like 10 was the only answer. 9 is between 9 and 11. It's like asking somebody a number from 50 to 60, and they're allowed to say 50. It's within that range.
Between, not that number, between.
If you would have said in the middle, I think.
The question said, what the question, please rewind it.
Drink it, like, to me right now is about a 3.
About a 3?
Yep.
Okay. Can you give me a number between 9 and 11?
Between.
9.
Between 9 and 11 was not 9, not 11. Between 9 and 11 is 10.
It sounds to me like a range rather than what's in the middle.
Counsel, my interpretation of between 9 and 11 is 10. Okay. Please proceed.
Okay. Can you do me a favor and hop on the car?
Yeah, close.
You got no weapons on it?
Not yet.
I'll have you walk right back there, okay? I'm gonna shut my front lights off. Just hang on right there. Would you be willing to do some standard field sobrieties to make sure you're okay to drive? Cool. I'm gonna have to walk right over here, okay?
Your Honor, if I just made a note for the record at this point in time,
What time did you pause?
that was at 3 minutes and 48 seconds.
Okay.
I'm sorry about that, Your Honor.
That's okay.
She had just given birth 3 months ago. Not sure how much that tends to play in somebody's behavior or anything like that, but just wanted to know for the record those were restrictions.
I've had 3 children. I don't know how that would, relate into that or not.
I don't know, I never given birth before. I was, you know better than I would.
Perfect. Do you have no medical issues with your eyes? No traumatic brain injuries, nothing like that?
No.
Perfect, awesome. Keep your arms out by your side. You're gonna follow the tip of my finger with your eyes and your eyes only, okay? Try not to move your head at all. Don't move your head.
Just know for the record that starts at 4:05 in the video.
Okay, all right.
Hello, sorry.
Keep watching. Alright, this next one we're gonna do.
So good. We started at 4:05 with that test, and I had 5:25, so that was about a minute and a half. So it was a bit unusually long for that sort of test. You can see he's not convinced. He's got somebody pursued.
Well, counsel, you cannot make an argument as to whether or not somebody's convinced or not. You don't have the officer here to testify as to whether he was convinced or not.
No, but
That is your summary and opinion based upon watching this.
no, of course I'm not.
But you cannot tell the court what somebody's thinking or feeling unless this officer says it right on the record.
Sure.
Right on the video.
So Mr. Kuzmiak is not allowed to say what the officer said or felt, right? Also,
Counsel, when I'm talking right now, I'm talking about this right here and your statement that he's obviously not convinced.
okay.
Okay, so if there's another statement by Mr. Kuzmiak, we'll address it at that time.
Well, then I would just state clearly, after reviewing hundreds of videos over 10 years, this is an unusually long test. That's my argument.
Okay,
You see this line right here?
Yes.
Would you agree that that line is pretty straight? This level?
We.
Good. So this one we're gonna do a lawful test, okay? If you would like to take your shoes off, I don't see any debris. Or you can keep your shoes on, okay?
Good one.
Cool. So this one, you're gonna put your left foot on the line.
Left foot.
Yeah, left foot on the line, right foot right in front of it. Put your
And.
hands on your side, yep. So left foot on the line, right foot in front of your left foot.
Ready?
Put your right foot in front of your left foot.
Ready?
So when I tell you to begin, you're gonna take 9 heel-to-toe steps forward. Okay, when you reach 9, you're gonna plant your lead foot. Using your rear foot, you're gonna take a series of small steps to turn around, 9 steps back. Okay, let me demonstrate it for you.
Moving forward. And go
I'll
back.
demonstrate it for you, okay? 1, 2, 3. So on how many steps?
3.
How many are you gonna take?
9.
You're gonna take 9, correct. You're gonna plant your lead foot. Using your rear foot, you're gonna take a series of small steps to turn around. 1,
Start.
2, 3. So on to how many? 9, perfect.
First.
Nope, you're gonna do 9 the entire time, okay?
But you did 3, okay?
Yes, just to demonstrate it for you, I did 3, okay? The entire time you do this, keep your arms out by your side.
Okay.
You're gonna stare at your feet, you're gonna count each step out loud, and do not stop until you feel you have completed. Do you understand all these instructions?
Yeah.
Alright, you may begin.
1,
Make sure you start your feet.
2, 3,
Make sure you start your feet, okay?
4, 5,
You're not looking at your feet.
6.
Your Honor, this is at 7:01. I would indicate that, in the directions that he initially gave her, he never told her to stare at her feet. He only gives her that direction after she begins to trip her up.
No. No, go back. Because at the beginning, he says, look down at your feet. Just go back to when he starts it.
Okay.
1,
Make sure you start your feet. Can you do 9 the entire time?
I'm gonna go back to where he's giving directions, Your Honor.
No, just go back like to it's at 6:35. Go back to 6:25.
Okay. Okay. Can I start at 6:16 instead?
That's fine.
Thanks.
3, so on how many steps? How many do you take?
9,
You're gonna take 9, correct. You're gonna plant your lead foot, using your rear foot, you're gonna take a series of small steps to turn around. 1,
start.
2, 3, so on how many? 9, perfect.
First,
No, you're gonna do 9 the entire time, okay?
but you did 3, okay?
Yes, just to demonstrate it for you, I did 3, okay? The entire time you do this, keep your arms out by your side.
Okay.
You're gonna stare at your feet, you're gonna count each step out loud, and do not stop until you feel you have completed. Do you understand all these instructions?
Yeah,
You may begin.
Your Honor, I understand
So
that he said that right before she.
yes, okay.
I just that, sorry. But, I would just note that for the whole minute that he was, demonstrating it, he didn't mention anything about staring at the feet until the last second before she began, but he did mention it to her.
Yes, he sure did. Okay.
Starting the video again at 6:50.
1,
Make sure you start your feet.
2, 3,
Make sure you start your feet, okay?
4, 5,
You're not looking at your feet.
6,
Make sure you're looking at your feet, okay?
9, 5, 6, 7, 1, 2, 3, 4, 5, 6, 7, 8.
Are you done?
Yes.
Now, this next one we're gonna do, this one I'm gonna demonstrate it, and then I'm gonna ask you to follow, okay?
Yes.
But you go ahead and face me, keep your arms on by your side for now. Okay, this one, we're gonna raise your right foot or your left foot, whichever one you prefer to raise, okay?
You said right foot over left foot, but,
Right foot or your left foot.
or, okay.
Yep, whichever one is more comfortable for you, okay? You're gonna raise your foot about 6 inches off the ground. You're gonna point your toe forward. You're gonna stare at your foot and you're gonna count 1001, 1002, 1003, so on until I tell you to stop.
Then,
Yep, so 1001,
how far do you
1002,
wanna go?
until I tell you to stop. Okay, it's about 30 seconds.
Okay,
So the entire time you do is keep
so
your arms down by
basically
your side.
30.
So keep your arms down by your side. You're gonna stare at your foot. Make sure you count out loud. And do not stop until I tell you to, okay? Do you understand all of these instructions?
Yeah.
All right, you may begin.
1001, 1002, 1003, 1004, 1005, 1006, 1007, 2007, 2009, 2010, 2011, 2012, 2013, 2014, 2015, 2016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, 2024, 2025, 2026,
Keep going.
2027,
All right,
2028.
you can stop. So the state admission requires that you must submit to a preliminary breath analysis found request of a police officer. Failure to do so could result in civil infraction and a penalty of up to $100. Will you take a PBT?
No,
You will not? Okay, it does not mean you're not gonna go to jail, okay? So a lot,
I don't,
so you're not gonna take a PBT?
like a rough eyes you're saying?
Yes.
Yeah, I won't take one.
Okay,
I know, I don't have to.
okay. So it does not mean you're not, you should be still gonna arrest.
That's-
Okay,
okay.
you're gonna be under arrest now for 3 months intoxicated, okay?
I'm.
Yes, ma'am.
Well, for saying, yeah, like,
Well, what happened? If you were to say yes, you're under that legal limit, or even if you're a little bit over, I'm very legal, okay? So a little bit over, we'll figure out right. We'll figure out a way.
like, so I said, no, I don't get that, like, right, or like. So you said you
Well, I
were,
don't know
like,
if you're about to,
doing
you
it.
know what I'm saying?
Yeah,
So, Your Honor, at 10:08, he goes, "We don't know if you're intoxicated or not," which seems to suggest he had no probable cause at all. And we see in the video, she barely messes up. She didn't have any balance issues. She never slurred her words. In fact, there were a few times he tried to trip her up, and she actually corrected herself and corrected him.
What?
For instance, he said, "I just took 3 steps. How many are you gonna take?" Thinking that she might be saying 3 and didn't listen to the direction.
Again, you cannot, counsel, Tom, please stand up when you're addressing the court.
Sorry, Your Honor.
You cannot tell the court why the officer stated what he stated. Okay, I heard the officer say, I took 3. How many are you going to take? She said 9. Whether it was to trip her up, whether it's to confirm she knew the answer or the what her instructions were, we don't know. So that we're not doing that.
Well, that, I can make an argument, Your Honor, and I've got great discretion on the arguments that I can make.
Counsel, you have great discretion on the arguments you can make, absolutely. But I'm not going to have you tell me why the officer said to her 9, whether it's to trip her up or not.
Okay.
Okay, we're not doing
An
that.
argument that say it appears that one could interpret it in such a way that the officer may have tried to see if she would get tripped up in the moment, and she proved in that moment, if that was the case, that wasn't.
Okay, and then when she was doing the test the first time, she got to 9 and then she started back over at 5. I watched that.
I don't think that's what happened, Your Honor.
Okay, let's rewind it. That's 100% what happened,
You're
counsel.
talking about the heel to toe test?
Yep.
Okay. I think that was 6. We'll start at 6:41. That's how
Okay.
we started.
No, she started.
Sorry?
Go ahead.
For your feet, you're gonna count each step out loud and do not stop until you feel you have completed. Do you understand all these instructions?
Yeah.
You may begin.
So initially, Your Honor, he said, "Don't stop until 9 and then turn around." And then he tells her, "Don't stop until you feel you have ended." Now, that's contradictory in direction. First he says, "Do 9 and then make your way back." Then he tells her, "Don't stop."
Rewind that again, counsel.
Thank you.
Do 9 the entire time, okay?
But you did 3, okay?
Okay, just to demonstrate it for you, I did 3, okay? The entire time you do this, keep your arms out by your side.
Okay.
You're gonna stare at your feet, you're gonna count each step out loud, and do not stop until you feel you have completed. Do you understand all these instructions?
Yeah.
Fine, you may pause, please.
Okay. What I heard is that the instructions were given.
Yes.
Multiple times that your client goes to 9.
Yes.
Then he says, stop when you feel you've completed. Completed per the instructions.
That's that didn't say pretty instruction.
That's the way this court's interpreting it. Okay, because he was very clear. 9 and 9. 9, some small little steps to turn around and do another 9.
Would it have hurt for him to reiterate again that it's 9 instead of whatever she feels?
He said 9 a lot of times, but let's please press play again.
Whatever she feels does not mean 9. Can we agree on that?
No, it says when you feel you've completed. Rewind it one more time.
Okay.
The entire time you do this, keep your arms out by your side.
Okay.
You're gonna stare at your feet, you're gonna count each step out loud, and do not stop until you feel you have completed.
So you feel you've completed with the instructions, completed the test per the instructions.
I think that this will be the reason.
That may be your that is absolutely what you can think, counsel. That is not how this court interprets that, but you may
Understood.
press play.
Very good.
Do you understand all these instructions?
Yeah.
Fine, you may begin.
1,
Make sure you stare at your feet.
2, 3,
Make sure you stare at your feet, okay?
4, 5,
You're not looking at your feet.
6,
Make sure you look at your feet, okay?
9,
No, pause, please. Not only did she start back over after she hit 9, she completely missed number 8 in her counting as well when she was doing that. So,
And I would argue that, I'm sorry, I didn't mean to cut you off if you had a good thought.
no, go ahead, counsel.
I would just put forth that,
Again, please stand up when you address.
I'm so sorry, Your Honor. I would just put on the record that reasonable person pulled over. It's reasonable to be under high stress, high anxiety, trying to perform these tests to the T. There was no issue in the nystagmus test.
Well, I don't know if there's an issue or not. I mean, I don't have anybody here to testify as to that. You want the court to view the video that this court just viewed and find that there's not probable cause to arrest your client for operating while under the influence.
Well,
Or intoxicated, correct?
Failure for SFSTs alone, Your Honor, is not enough, and numerous courts have ruled that there needs to be slurring, there needs to be odor, and at the end, he goes, "We don't know." So now that he didn't articulate on the record, he knew that his body cam was on. There's zero articulation that he thinks that she's drunk. He even says it himself. We don't need the officer's testimony. He goes, "We don't know."
Counsel,
Yes, Your Honor.
I 100% disagree that we do not need the officer's testimony. Because that may be taken out of context. I don't know. I can tell you what I observe right here. There's something that's going on, and that's not somebody that's 100% sober. I 100% can tell you that. That is what this court sees at this particular moment. Watching the SFST with the heel to toe test and listening to the interaction between your client and the officer while your client was still in the car. That is what I can tell at this point. So I do think that the officer's testimony is necessary for this court to make a complete ruling, because whether the officer stated, we don't know if you're intoxicated or not, that was in response to the question of your client about so I don't get that consideration if I didn't take the PBT.
Yeah, he says, "We don't know." So that means he doesn't have probable cause to believe that the crime of operating while intoxicated has been committed, which literally destroys probable cause. Even if he came in here and contradicted that, doesn't matter. He can say whatever he wants on the record. The video shows itself at the time of the offense, which is what we evaluate, not afterwards, but at the time, whether there was probable cause. And there clearly is not. Because
Well, no, that's not clearly is absolutely not accurate, Colin.
well, he clearly
Because
said-
what I'm seeing
yes.
is that there's probable cause for your client to have been arrested for operating while intoxicated.
I see. But the issue here is we don't hear any slurred words. She doesn't trip over her words. She gets all her words clearly. She can articulate where she lives. She didn't have any balance issues. Even when she tripped up, she corrected herself, especially on the 1027 it was. She corrected herself. This is not a person that shows signs of intoxication. It shows high competence in a high stress situation.
Or counsel, perhaps it could show somebody that consumes a lot of alcohol and can contain themselves. I don't know.
But
So then we're going to have the officer present. We're going to set this for an evidentiary hearing so we can hear from the officer.
I mean, let me ask you a question, Your Honor. If the officer comes here and testifies and says exactly, well, I believe, she was intoxicated, but stuff in the video. I mean, are we just delaying the inevitable that we're gonna
Counsel, I am not, listen, if I could do all that, I could tell you what the winning lottery numbers were. I want to hear what the testimony is from the officer, and then I will make my ruling. Let's set this for an evidentiary hearing on, what does January 21st look like for us, or 28th, Ellie?
jury trial that we run, I can't do it.
What week is your jury trial, counsel?
Week of the 26th. So no,
Okay, so we can potentially do the 21st.
I'm sorry, I can't do the 21st either, Your Honor. I'm just doing it that day.
The 4th, February 4th.
The 4th is good for me, Your Honor.
Does that work for the people?
Your Honor, I think it works for the people. I just need to confirm with the officers that he's available.
Okay, what, does that work for us, Ellie?
As long as it's in the late one.
Okay, 11 a.m.
Let's do 11:30.
Okay, 11:30 a.m. If Mr. Kuzmiak, the officer, is not available, well, if you could please communicate with the officer today and then send an email, including the court and Mr. Arabo, on the availability one way or the other, so that we're all on the same page. Okay? All right, body conditions are continued. Thank you very much.
Thank you so much, Your Honor.
Thank you. And then we have we have to call this third.
Anything for us?
No, you're all set. Body conditions are continued. Thank you. You as well.